Sponsors of Senate Resolution number 395, four of whom, despite differences, I have my respects, except for one, Mr. President, are urging Senator Ronald De La Rosa to voluntarily surrender to the peoples of the proper authorities and seek judicial remedies in accordance with the Constitution and applicable laws and rules. Mr. President, I respectfully oppose this resolution on the ground that the moment Senator De La Rosa surrenders, he will be immediately brought outside Philippine territory and deprived of the protection and remedies of Philippine laws and courts. To surrender Senator De La Rosa is to effectively surrender Philippine sovereignty itself. The International Criminal Court Pretrial Chamber 1, Mr. President, has confirmed that it issued a warrant of arrest against Senator De La Rosa on November 6, 2025. It unsealed the warrant only on May 11, 2026. The warrant orders the arrest and surrender of Senator De La Rosa under Article 102 of the Rome Statute. To surrender Senator De La Rosa is to deliver him to the custody of the ICC in the Netherlands, a foreign jurisdiction where Philippine laws have no force and Philippine courts can do nothing. While the sponsors pretend that they want Senator De La Rosa surrendered to authorities in the Philippines, in reality, they want him handcuffed, dragged to the airport, dumped on a plane, and banished to the clutches of the ICC in the Netherlands. While the sponsors claim they want Senator De La Rosa to avail of Philippine judicial remedies, in reality, they want him removed from territorial jurisdiction of the Philippine courts and therefore deprived of the rights and remedies that every Filipino enjoy under our laws and constitutional protection of due process. In fact, Mr. President, if the sponsors will have their way, Senator De La Rosa is transported to the Netherlands. The constitutional issues now pending before the Philippine Supreme Court will become moot and academic. The Philippine Supreme Court will be ousted of jurisdiction and prevented from fulfilling its constitutional mandate. There will be no end to this constitutional crisis, for in the years to come, the ICC, with much delight, will pick us up one by one, Mr. President. Only the Supreme Court, Mr. President, can stop this nonsense. The sponsors of Senate Resolution number 395 cited the service of warrants of arrest on the late former Senator Juan Ponce Enrile, former Senators Laila de Lima, and former Senator Antonio Trillanes. But please take note, Mr. President, they did not mention that their co-sponsor, Panfilo Lacson, evaded service of arrest warrant. The sponsors acknowledged that the late former Senator Enrile, former Senator De Lima, and former Senator Trillanes were all subjected to arrest warrants issued by local courts. For the record, Mr. President, all of them have exercised their rights under Philippine laws and availed of Philippine judicial remedies. Yet the sponsors are blind to the peculiar situation of Senator De La Rosa. Unlike the late Senator Enrile et al., who faced arrest warrants issued by Philippine courts, Senator De La Rosa is facing an arrest warrant issued by the ICC, a foreign court which jurisdiction the Philippines does not recognize anymore. Moreover, unlike the former Senator Enrile et al., who availed of the rights and remedies of Philippine laws and courts, Senator De La Rosa will be deprived of all this, as he will be banished to foreign land on the other side of the planet, beyond the reach of Philippine laws, and forever detached from his family and constituents. Therefore, if the sponsors are sincere in their desire that Senator De La Rosa be accorded the same rights and remedies as those enjoyed by Senator Enrile et al. They should not allow his surrender to the ICC. They should instead withdraw Resolution number 395. The sponsors recognize that under Republic Act 9851, it is the regional trial court that has exclusive original jurisdiction over offenses constituting crimes against humanity. This statement of the sponsors reinforces the position of the majority that the ICC warrant of arrest should not be implemented against Senator De la Rosa, and he must remain under the Senate custodial protection under the ICC arrest until the ICC arrest is quashed by Philippine court. First, Section 18 of RA 9851 provides that it is the Philippine Regional Trial Court that has exclusive original jurisdiction over crimes against humanity. Section 17 allows the transfer of jurisdiction to a foreign court only by way of extradition and provided by the Philippine court, provided the Philippine court is unable to try and decide the case. Therefore, RA 9851 itself bars the ICC from taking jurisdiction the acts attributed to Senator De la Rosa. Kagaya po ng nasabi ko na kahapon, Mr. President, wala po tayong extradition treaty sa ICC. At wala na po tayong membership sa Rome Statute sapagkat nag-withdraw na po tayo. Sa makatwid, wala na pong treaty. Yun po ay nakasaad sa Article 17 ng 9851. Second, at the United Nations, the Philippine government, through the permanent representative, pronounced that the state policy under RA 9851, Philippine courts have the exclusive jurisdiction over crimes against humanity. It also declared that Philippine courts have the competence and capacity to try and decide these cases. Eh kung ganun po pala, this is the national policy already articulated even before the halls of the United Nations. Eh bakit pinipilit pa natin na iserve ang isang warrant of arrest na hindi na natin kinikilala ang jurisdiction ng lintik na ICC na yan? Hence, the Philippine state policy is to assert and exercise local jurisdiction rather than recognize foreign jurisdiction such as that of the ICC. Third, the Philippine government has assumed and exercised local jurisdiction under RA 9851 over the crimes arising from extrajudicial killings allegedly committed by Senator De la Rosa. Philippine local jurisdiction already set in when Senator De la Rosa was served a subpoena by the CIDG in connection with its investigation of said extrajudicial killings. Senator De la Rosa has stated that he is ready to respond to the subpoena. It is of no moment, Mr. President, that today the CIDG withdrew the subpoena. It is a legal ruse. It's a legal legerdemain. Ang akala nila kung withdraw nila yung subpoena, wini-withdraw na yung case. No, Mr. President, the case is kicking and alive. It triggered already the jurisdiction of our National Prosecution Service and eventually the courts of this country.